Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Well, we are back in the car. That's a good thing. Just had a hearing. Driving an hour or so back to my office. Hearing didn't go so well. Didn't quite go our way, but that's the way it happens sometimes. What I want to talk to you all about today is there's a whole hubbub. Mo Greenway released a story saying that SAPA is protecting medical marijuana cardholders in Missouri. That's not true. That's the bottom line. Here's the reality of this. SAPA is a wet newspaper, pointless platitude. The Second Amendment Protection Act that was passed has so many legal flaws and holes to render it next to useless. Never mind the fact that federal preemption blows what parts of it might have had some value. The threat isn't federal law. The threat to medical marijuana cardholders is not federal law. As long as you are a consumer of marijuana, medical, legalized in legal states, if you are a marijuana consumer, you cannot purchase or possess a firearm under federal law. State games aside, SAPA aside, that remains federal law. Now, will the state enforce federal law? No, they weren't going to do that before anyway. All that might have happened is your file might have been sent over to a fed. The feds really don't care about Jimmy Dimebag having a gun at home while he's smoking some marijuana to help with his cancer. Really, they don't care. The feds aren't interested in that. Now, that surprises a lot of people, but they're not interested. They don't care. They're not coming after you. The threat is the unknown. The threat is Missouri law. And by the way, possessing a firearm while you're under the influence is going to get you busted almost every time, whether you're under the influence of alcohol or any chemical substance, if you are actively in possession of that firearm. Meaning, if you're token up on the back porch and you got your Smith & Wesson 40 tucked into your waistband, or if you're the son of a bitch that stole mine 10 years ago, you got my Smith & Wesson 40 tucked into your waistband, you're probably going to go to jail if you're caught. Now, if you're smoking a joint, sitting on the park bench in front of the county courthouse, you're increasing the likelihood. If you're in your backyard and it's a fenced yard, well, you're decreasing the likelihood. So you'll be smart as far as where you consume your medicine. That aside, we've talked about this before, that Missouri state law makes it illegal for you to possess a firearm if you are in a habitually drugged condition. Now, what does that mean, that phrase, in a habitually drugged condition? We've discussed this several times, and every time people start pointing out that, that could be somebody who takes OxyContin for their back, or, they take Sudafed because they broke their nose when they were in the Army, or they take, antidepressants, or any other habitually drugged condition. So, you're right. That law could be extended to all of that. And there's not really a good argument yet, because our Supreme Court, our courts of appeals, haven't ruled on it. We don't have a case that says this is what this clause means. And the reason we don't have that case is because it is such a hard thing to show. How do you show somebody's in a habitually drugged condition? Or they are a habitual drunkard? Well, do you show their bar tab for the past 6 months? Okay, maybe that would cut it. But what if they're not drinking at the bar? What if they're not putting on a credit card? What if they pay cash for a 12-pack and they go sit and they drink? So habitually drugged condition is a very hard thing to prove. However, the Wilson v. Lynch case that came out of Utah, the court held that possession of a medical marijuana card is prima facie evidence that you are an illegal drug user. Now, what's the step there? Is it a step to go from an illegal drug user to habitually drug condition? Maybe, but all of your purchase records from dispensaries are available. So you can purchase your 4 ounces a month. You can purchase your 8 ounces. Have your 8 ounces. Okay, you can have this. But that record is available. And if you are making your maximum purchase every month, can they use that as evidence to show that you are in a habitually drugged condition? Well, arguably yes. Yes, they can. I don't know of any jurisdiction that's been done, but it can be. And that's where we run into a problem. Any attorney that is saying, no, you're fine, you're good to carry a gun, you're good to buy a gun, you're good to possess a gun while you're a medical marijuana card holder, is taking a chance. Because we don't know how the court is going to rule on habitually drugged condition or habitual drunkard. Okay? That's the statute. That's it. I don't know. So can I say to you as a matter of law that your smoking 4 ounces of marijuana a month is a habitual drug condition? I can't. The court hasn't ruled. But attorneys, pardon the use of the word, by nature are conservative. We have to be. Even if we're individually Democrats, we have to be conservative in our legal advice. Okay? We have to tell you, hey, we don't know how the court can come down on this. As I said, back when the amendment passed, before it took effect, we don't know. Do you want to be the test case? Do you want to be the person in custody waiting to find out if the Court of Appeals is going to rule in your favor and habitually drug condition excludes people that have prescriptions? Notice that word, because we don't have a prescription for medical marijuana. Or if it includes medical marijuana. Because the court may very well carve an exception out of that for prescribed medication. But that leaves us hanging in medical marijuana. Because we don't have prescriptions, we have a certification that you meet the government's list. Okay? This is why when I see all of these posts on Facebook, people saying, yo, this is great, we're good to go, you can do this. No, we don't know that. And honestly, I don't get into these debates on Facebook because I'm not going to argue law with a non-lawyer who doesn't know what they're talking about. Occasionally I'll make a mention on some of the marijuana groups I'm in that, yeah, you probably shouldn't do this, but I'm not going to get into a long debate on it. It serves no purpose. That said, please, if you have a question about what I just said in this video, and don't forget to like and subscribe. Got to do that. We need it. help the logarithm and all that crap. But if you have a question about this, go talk to your own attorney. Pay the consult fee. Sit down with an attorney. Pay for an hour of their time to research it and talk to you about it. And say, hey, what is it you think? Okay? You need to understand that. Hell, direct them to the video before you pay for the hour of time. I don't care. But the bottom line is, we don't know and we can't advise you, and I'm using the royal we, but I'm speaking for me. I can't tell you as a matter of law that you can possess a firearm as a medical marijuana user. One, it is still in violation of federal law to possess, not just purchase or possess. People look at 18 U.S.C. 922, they go to D, but they never go all the way to G. Okay, you can't stop with D, which makes it illegal to sell you a gun. You have to go to G, which makes it illegal for you to possess a firearm or ammunition. So, you have to look it up and make a decision for yourself. If you're willing to take the risk to be a test case, that's fine. That's your call. But you're making that decision knowingly. Okay? You've looked at it intelligently, you understand, and you're volunteering to take that risk. That's cool, man. I support you. I'm happy to defend you. If you hire me, we will argue this out and try to get a good result for all of us. But you can't come back and say, well, you didn't tell me or you lied to me, because no, we don't know. That said, I think that it's a risk you probably shouldn't take. So, what do? Well, do you stop using your medication during hunting season? Maybe that's what you do. Do you purposely plan to spend X dollars a month at a dispensary and show that you have a track record of, a quarter pound a month? Shit, man, I don't know. Maybe. Do you home grow? Well, nobody knows how much you're going to have. You know how much you're supposed to have. We're not going to get into that on this video. So there are options for you, but the question here is, if you're buying from a dispensary, or the point is, if you're buying from a dispensary, it can be proven how much you're buying. There's a database that you don't buy more than you're allowed to have. Okay? That database is going to show how much you purchased each month. So think about that. Be smart. And please, for the love of God, don't believe random legal advice from Facebook. Don't believe what I'm telling you, man. This is information. I'm not giving you legal advice. I'm not your attorney. This is information. It's entertainment, man. Go talk to your attorney, pay your attorney, talk to him, and then make a decision, a knowing, intelligent, voluntary decision based upon the advice that you received from your attorney. So, thank you very much. Please hit like, subscribe. I'll be talking to you again real soon.